Mic check. I'm on. Hey, what's going on? How is everybody doing out there today? Let me get people some time to get in. My name is Nathan Lloyd. If it's your first time here, welcome to the channel. And if you're here for today's video, I do police breakdowns. So we're going to look at the body camera, we look at the law, and we break it down to see if you can come to the determination if police were justified. There's two rules that I generally like to put out when we do these videos. Number one, we are going to look at the incident itself. So the media narrative about race, about this, about that, we throw all of that away and we look at each incident individually. In this incident, we're going to look at the facts surrounding this incident. There may be other things that come out in the future, but what we really want to focus on is what happened, what the officers knew, and how the law treats it, and if we can make a determination on whether we believe that is justified or not. Let me turn my audio down. So I generally don't give my opinion, and I'm not going to give it on this particular instance either. And that's because I don't want your view of what happened to be colored by my opinion before we get into it. You know what I mean? Here is Barney Tensel, non-lawyer prediction. They had to shoot a second shot early. If they had shot a second shot earlier, it would be okay. But the way it turned out, it's not. Also cover the Ronald Green case. Yes, I will cover the Ronald Green case. I got to do one at a time. Thank you for the super chat, Barney. but Barney wants to get to the conclusion. So Barney believes that it may not be okay. So that's an interesting take. But let's all get on the same page first. So you know what? Let's start. Good morning, Matt. So let's start. I'm gonna play the intro, get a couple of people seconds to go to it, and then we'll start the show. That is how you do it. So yeah, so I don't even know why I played that intro. I usually never play the intro, but I thought, hell, since StreamYard allows me to play the intro now, I'll play the intro. All right, so today we're talking about the case of Andrew Brown Jr., and this is from North Carolina, Elizabeth, North Carolina. So it's always good when we start with these cases. It's better to start with the law first, and then we'll move on to the facts, because the law is going to tell us how we should be thinking about things going into the facts. Then the facts are going to, then we'll take the facts and apply them to the law that is presented. And then remember, it's going to be you that comes out to determination. So we only want to be factual, number one, and we only want to be, and we only want to apply the facts that we know as of now to the law. So we want to remove all the other BS from it, right? I'm not Benjamin Crump. I'm not Robert Barnes on the right. We just want to try to come to the best possible legal conclusion based on what the law is now and based on what the evidence is now. So first, let me start. First, before we even get into that, I want to give people a couple more seconds. I want to go back to two cases real quick that I've covered in the past that I'm going to do updates for. First, the Chauvin juror. The guy who said that he was never wearing the shirt. It's funny, he has a podcast. I'm going to put it up here so you guys can see it. But his podcast, he's wearing that same shirt, which I thought was interesting. So I think there may be a little bit more to this Chauvin juror issue that may come up. This is actually from his YouTube channel. So this video is from his YouTube channel. He does his whole show in this shirt. Remember, the shirt that he said that he never remembered wearing or didn't remember owning. I think that may be a problem. So, but because he may have a bias doesn't mean he was biased in his opinion. But, I think this is just more fuel for the fire. So the Chauvin juror, I think by him saying he never went to any of these rallies and never even owned that particular shirt, looks like it may be a problem for him. But, hey, what it is what it is. And a second quick update I wanted to give you guys before we move on to the Chauvin juror stuff is this one, which I find is fascinating. Most people don't remember, or when I say Rayshard Brooks, a lot of people don't even know who I'm talking about. But Rayshard Brooks is the gentleman in Atlanta, the guy who actually had the fight with the cops in Atlanta and then got shot when he grabbed one of the cops' tasers. Let me pull this up. So this is Rayshard Brooks, and this is the officer that was charged with this murder, Brandon Ralph. So come to find out, the officer in that case actually was reinstated to the force. So this is a very interesting read. It's weird because The officer now is under criminal indictment for murdering Brooks, but is now reinstated to the force, is just on leave. So he's still getting paid to be a police officer. And the reason why he was reinstated, I think, is interesting. I think the reason why he was reinstated is because they did a sham investigation. They literally did a sham investigation. They tried to fire him as soon as possible. They didn't even fill out the forms right. If you guys can read through this article, but I'm going to be covering this again because this is out of all the police shootings, this is the one that I've gotten when I give my opinion on. I got incorrect because I said no reasonable prosecutor would bring charges, but the DA in Atlanta, he was under for re-election, had like major ethics violations, and indicted this cop, even no matter what the evidence was. And I just think it's weird that now the cop is literally under indictment for murder and now is reinstated to the police force. So, for most of you guys who do know, I believe this shooting was justified. I believe it was justified because of the tactics in law and the fact that, a taser there in Atlanta is considered a dangerous weapon. I know some people disagree with that, but it just is. And, it's a weird case, but it is. Now, I do also want to say this. There are a lot of people so everyone understands. I get a lot of, I'll say, hate because of when I give my opinion on these cases. Like, for instance, I thought Robert Blake, the guy with the knife, fighting with the cops, I thought that was a justified shooting. It was, I think it was clear, but a lot of people on the left thought it was unjustified, even though he had a knife, even though he's reaching to the car. It's crazy. The young woman with the knife to the other young lady, remember that one? I thought that was justified, right? There's a lot of people on it. So it just, I can't play to any base. And then on the right, I have the same things too with the right? I have, the Ashley Babbitt. I think that was 100% justified also. I also think that, what's his name? George Floyd. I think that was a murder, right? So it's not about each individual case we can disagree on, but it's about how we get there. So now let me stop teasing it all this time and let's start getting to the presentation. All right. So you guys are here. You guys have been with me for a long time. You guys know where we're going to get down to. We start with the law, right? Because the law is what it's all about. The law is going to tell us what we need to look for, how we need to do it. It's the due process piece of it, what we need to do. So let's look at the law to understand what we're going to be looking for before we look at the facts. So then we're going to look at the facts. Then we're going to try to apply the law that, as we know it, to those facts. And then hopefully you'll share this video, like this video, send me some super chats, because this is going to be demonetized, obviously, because I'm showing you a police shooting. And that's why it makes it hard for me to go through these videos, because YouTube is not very friendly with these videos and trying to make money off these videos. But I think it's an important piece to it, so you can understand how the law actually works within the real world. So let's start. Let's go right to the law. So we're going right to constitutional piece of this. Let me present this so we can all see it. So let me share my presentation. Oops. Screen share this. And we are going right to it. Chrome tab, this one. Boom. And I am going to present this for you guys. All right. So these are two cases in the United States for all police officers that are going, when you use force, these two cases you're going to hear about, no matter where you are, about police use of force. These are the seminal cases. Here they are. You should go read them if you're into this type of stuff. If you really want to understand what police officers need to do and how they have to use force, these are the cases that you're going to hear and everything. I'm going to tell you, no other YouTube commentator was even mentioning these cases. I've been breaking police cases down for about a year now, and I've been only using these two cases, and I've been drilling it into your head. So most of my long-term fans, people who know me from Breonna Taylor, right? I always go right back to these cases. And it's weird because now you see all these other YouTube lawyers talking about Graham v. Connor. They had never mentioned it ever in their life before, but now they're going to it because this is the seminal case. And I've known this obviously for years, but this is the seminal case in law enforcement. And so is Tennessee v. Gardner. They teach police officers about Tennessee v. Gardner and Graham v. Connor in the police academy. So these are the two cases that are used unanimously across the country. This is the standard for police use of force. So that's why I drill it. That's why we always talk about it. And that's what you're going to hear about today. First, let's talk about our first case. Let's talk about Tennessee v. Gardner. So Tennessee v. Gardner is about a serious threat, and Graham v. Connor is about the objectively reasonable standard. I'll go into a little bit more fine detail so we can all understand. Right. So I'm going to start with Tennessee v. Gardner. Now, Tennessee v. Gardner it stands for the proposition that police officers cannot shoot fleeing felons in the back. Right? They can't do it unless so they're forbidden to do that. Right? Unless that fleeing felon is an immediate threat to members of the public or to other officers. So, for instance, like the Walter Scott case. This is a famous case out of, I'm not sure if it's North or South Carolina, where this guy, Walter Scott, was running from a police officer, presented his back. Before this, he fought with a police officer, right? And then started running. The police officer gets in the shooting stance and fires and shoots him in the back. And this police officer was charged, and I think he's doing like 20 years in prison. But this case stands for the proposition that you cannot shoot fleeing felons in the back unless that felon poses a serious threat of danger. If that person had a bomb or that person had a gun and shooting at people or something like that, then you can fire in those situations. But if the person is just running away, Tennessee v. Gardner stands for the proposition that you cannot shoot a fleeing felon in the back. Extremely important case. It's something that's taught in every if you're in law enforcement, you know about this, you've been taught about this, this is what it is. So that is essentially what we have to understand from Tennessee v. Gardner. And I think it's going to be extremely important when we're evaluating this case, is this a case that's going to implicate Tennessee v. Gardner? Is this person running away? Is this person being shot in the back? Is this person presenting a serious threat to people? That is what we're going to have to look at. Then from that, we're going to go to Graham v. Connor. Now, you know what? Let me tell you about what happened at Tennessee v. Gardner before we go to Graham v. Connor. So the TLDR for Tennessee v. Gardner is that in that case, there was a burglary that was occurring. And the police were called to the burglary. And they go to the house, and they don't see anything in front, but they saw a broken window. So one of the officers goes to the back of the home where they find Mr. Gardner. Gardner is running away. He jumps over the fence, and the police find that if he jumps over the fence, they're not going to be able to catch him. He's gone, right? The police officer says there was so much stuff between him, Gardner, and the fence that if Gardner jumps over the fence, it was gone. So Tennessee taught its officers, they trained their officers to shoot fleeing felons in the back and kill them, right? If you find that somebody's committed a felony and they're running from the officer, they are able to shoot that fleeing felon. Now, in Tennessee v. Gardner, both the officer was black and the person who was shot was black. So it was a black officer who shot a black suspect based on the training, based on Tennessee law. The Supreme Court struck down that law and said you can't shoot fleeing felons in the back unless they're a serious threat of danger. And obviously Gardner was not. So that's why we have Tennessee v. Gardner. So that's the crux of that case. The next case we have to go to is Graham v. Connor. Now, the facts of that case are similar but different. Now, the facts in Graham v. Connor is you had someone who was having a diabetic episode. So in Graham v. Connor, the plaintiff was having a diabetic episode. They asked their friend, "Well, take me to the store so I can get some orange juice, right? Because they need, I believe they took too much insulin and they needed sugar to get themselves back to the way they needed to be. So they went to the store to get oranges. So they go to in Graham, there's an officer sitting out in front of the gas station, and they see a car haul ass right to the front of the convenience store. Somebody jump out, run into the store, run back and forth around the store, and then run out the store. Right? The person runs in the store. 5 seconds later, the person runs out the store, jumps in the car, and the car speeds off down the block. So the officer sitting out in front of the convenience store is like, I just witnessed the robbery, right? That somebody they just robbed the store. I'm just sitting right here. They go, they pull over the vehicle. Hey, what just happened in the store? Graham gets out. He runs around the car like 4 times. The police have to, wrestle him up. So eventually the police stop him. They put handcuffs on him. And in Graham v. Connor, they like break his foot. Like they beat his ass, right? So then they find out. So eventually they call the convenience store. What happened? Supposedly when Graham goes into the store, the line is so long that he just runs back to the car and says, let's go to another store. Now, obviously, he could have just grabbed the orange juice and stood online and drunk the orange juice. It should have been okay. But he wasn't thinking. Obviously, he's having medical issues. They find out he actually has the medical issue. So they call the convenience store. The convenience store confirms they weren't robbed. Everything was safe. So they took Graham home, and Graham had to go to the hospital, and he sued. So Graham lost this lawsuit, right? Graham lost this lawsuit because the Supreme Court said, under those circumstances, it was reasonable for the officer to believe that this store was getting robbed. And they set forth some principles on how to judge all police use of force. And they've done this from that point on till today. We still use Graham v. Connor. Now, if you watch my coverage of the Derek Chauvin trial, this case was mentioned something like 100 times. The whole case came down to Graham v. Connor. The whole case. That case was a Graham v. Connor case. The defense talked about it. The prosecution talked about it. They all talked about Graham v. Connor. So this is the case. Any use of force, listen, I'm going to tell you this. If any lawyer is doing a police breakdown about use of force and don't mention Graham v. Connor, then, it's like, I don't know what they're doing. So that's what we're talking about. This is the case. This is the case. So let me move on because I've talked to Graham v. Connor. But so now the principles of Graham v. Connor are simple. First, they say, well, what was the call for service? What's the 911 call? Was it a cat in a tree or was it a bank robbery in progress? Obviously, if it's a bank robbery, then police are going to be more heightened to use force. The second was the suspect resisting arrest? The person resisting arrest, police can use force to overcome that resistance to arrest the individual. So that's another factor that should be considered. And the third factor is that they took this from our previous case, Tennessee v. Gardner, and instituted here, right? Was there a serious threat to life, safety, so forth and so forth? With the caveat, you can't shoot fleeing felons in the back, but the serious threat should be evaluated. And there are more factors that the court allows departments and things to use, for instance, how many officers versus how many subjects and so forth and so forth. But these are the key 3 factors that usually you would go to evaluate whether the officer's force was reasonable and justified, objectively reasonable at that. Now, one other thing about the objectively reasonable standard, it's about what a reasonable officer would do. So not a reasonable person. So you're talking about a reasonable officer who is trained, who's maybe done this before. And there's a difference between an officer who's been there for 2 days versus an officer who's been there for 10 years, right? So that's what we're talking about. Now, if you guys have any questions, also just let me know in the chat, and I'll answer questions on the way. But it's very important that you understand this. So there's a lot to go on. So first we have, you can't just shoot fleeing felons in the back unless they're serious threats. And then we have this objectively reasonable standard, and we'll evaluate them, use these standards to evaluate what we know. So I know this is a lot to take in, but we'll walk through it. All right. Woof. Let me see. Somebody says Boris is an incoherent rambler. All right. I'm glad. I hope I'm not Boris, but yes. So let's do it. So now I want to take you to the DA, because first, to understand this particular case and understand what's happening here with this case, we have to first, what are the facts? What is the 911 call, right? So now let's go through the factors. So what was the 911 call? What were police going there to do? So I have already keyed up the district attorney from that county, and he's going to tell us what the preparations were for law enforcement going into the situation. And then we can see what officers were, what was the 911 situation? What were officers, what did they know they were going into? Nate the lawyer, there's a list that describes reasonable. Somebody actually put something here, but I'll read that in a second. So where is that full video? Here we go. So I want you guys now, again, if we're going to do this, we have to do this methodically. So we're going to listen to the DA from this county, and that DA is going to, and this DA is going to give us the facts that the officers ran up to in going into the situation. So here we go.
Received information from a reliable, confidential source that Andrew Brown Jr. from Elizabeth City was selling drugs in Dare County. Detective Johnson contacted Pasquotank County and confirmed Mr. Brown's identity and that he is a known drug dealer. Upon learning this information, Detective Johnson, with the aid of the confidential informant, made 2 undercover buys from Brown on March 17th, 2021 and March 29th, 2021. Those buys were of cocaine and heroin, respectively. A later SBI lab analysis determined that the heroin was laced with fentanyl. Subsequently, arrest warrants were issued for Brown's arrest on April 20th, 2021. Simultaneous with the activity of the Dare County Sheriff's Office, Pasquotank County Sheriff's Office began collecting their own intelligence on the drug activity of Mr. Brown at his residence at 421 Perry Street. Detective Ryan Meads applied for and obtained a search warrant for the residence and vehicles of Mr. Brown. On Tuesday, April 20th, 2021, law enforcement now possessed 2 arrest warrants for the sale of controlled substances in Dare County, as well as a search warrant for the residence and vehicles of Mr. Brown. A joint team of law enforcement from Dare County and Pasquotank was assembled. The Dare County Drug Task Force was to provide surveillance, and the officers present that day were Detective Johnson, Sergeant Ruth, and Detective Langley. The Pasquotank Special Operation and Tactics team would serve the warrants and take Mr. Brown into custody. Their team consisted of Lieutenant Judge, Sergeant Meads, Deputy Morgan, Deputy Llewellyn, Deputy Bishop, Deputy Swindell, and Deputy Lunsford. Deputies Morgan, Llewellyn, Bishop, and Swindell were wearing body cameras. Their original plan was to serve the warrants on the night of April 20, 2021. However, Mr. Brown was not at his residence and could not be located by the surveillance team. On the morning of April 21, 2021, at approximately 5:30 a.m., law enforcement held a briefing here at the Pasquotank County Sheriff's Office and planned to serve the warrants on Mr. Brown. During the briefing conducted by Sergeant Meads, the team was briefed on Mr. Brown and his past involvement with law enforcement. It was relayed to the team that Mr. Brown has multiple resist arrest charges and convictions dating back to 1995. Additionally, Mr. Brown has assault with a deadly weapon, and assault inflicting serious injury convictions dating back to 95. Further, Mr. Brown has barricaded doorways during previous home search warrant instances. No children were believed to be at the location.
Okay. So we got through that. So just so we're clear. So we have 2 search warrants. We have 2 arrest warrants, a search warrant, controls, he supposedly has controlled substances. We have a team of officers, all in uniform, right? And they're going to execute the search warrant. They've been told ahead of time, right, that this is someone who's resisted arrest, has had weapons in the past, barricaded themselves in. So the officers, so when we talk about our gram factors again, and this is the 911 call, what are we going there for? Here, we're going there for a very specific reason. We have search warrants. This person is going into custody. And number 2, I think, is very appropriate. We don't have this whole difference like with Breonna Taylor. It was like, well, the police were in plain clothes. The police here are in uniform, and they're going in. So 911. This is not cat stuck in a tree. This is not really bank robbery, but it's closer to bank robbery, right? Than cat stuck in a tree. This is a lot closer to bank robbery than cat stuck in a tree. So we're here. So we're going into, and this is probably going to be a dangerous. This is a dangerous execute. They're executing a pretty dangerous warrant here, right? That's why they have the team. So for those of you, let me stop this. Let me put this back. So, oops. Let me get back to here. So on our first factor, the 911 call, I think if we were talking about, why are they there? Obviously, they're there for a very serious reason. So I think this lends in favor of the officers, right? The next thing is resisting arrest. And then last was serious threat. Now we're going to have to deal with these last two by looking at the video. So what I've done is, first, I want to let you watch the body cam videos uninterrupted, right? So we're going to watch the body cam videos uninterrupted. And then we'll answer our last two questions on these factors. And then we'll also apply the Tennessee v. Gardner holding to this particular case. So now let's watch the body cam footage for the three from the officers, so you can just see it yourself without any commentary. I'm not, because at first I was going to play the commentary of the DA, but I think he's coloring it in a way that may not be accurate. So let's let you just watch it plainly. Then we'll come back and we'll break it down. So here is the body cam footage from the officers.
The total length of officer involvement with Mr. Brown from the time they exited the vehicle until Mr. Brown was removed from the vehicle is 44 seconds.
Go, 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 go! Motherfucker! Stop the fucking car! Stop the goddamn car! Fuck!
This is the second video.
See your head! Let me see your head! Hey! Hey! Motherfucker! Stop the fucking car! Stop the goddamn car! Fuck! Hey! Let me see your head! Show me your head!
Okay, so that's it. That was the body cam footage. You guys have seen it all the way through. You saw the cops come up. You saw when they shot. You saw exactly what happened. So, Nate, is there systematic racism in the United States? Yes. In some instances, yes, there is. But to what degrees? It all depends. But I believe there's racism in the U.S. Yes. But again, it all depends on the degrees. It was worse in the 60s, but it's a lot different than it is now. And I think there are little quirks that need to be worked out. But I don't think it's as bad as it was with the Jim Crow era, for instance. So let's get back to, let me remove this. All right. So now you've seen the footage and you've seen what happened. Now this is a very, very quick video. Now let's break it down, right? Because now we have to see, was there, number one, was this person resisting arrest? I think that's a easy yes, right? This person was definitely resisting arrest, right? They came and said, get out the car, put your hands up. We're police everything. They're in the police cars. They're running. They're screaming police. Was he resisting arrest? I think, only, is there anybody out there who could make an argument that he wasn't resisting arrest? Like, really, I think, resisting arrest, I think we have that in spades. I don't think there's any reasonable person who's going to say he wasn't resisting arrest. That was too close to call. If it's a close call, who gets the presumption? The officers. Too close to call, the officers get the presumption. They're innocent until proven guilty. The state has to prove they weren't justified. So if it's 50-50, a 50-50 tie goes to the officers. I know a lot of people aren't going to like that, but that's the way it goes. Yes. So was this person, thank you for the super chat. So was this person resisting arrest? Yes. Right. You're under arrest, right? But the second piece of this now, where I think we're going to have a little issue, is going to be the last factor. It's going to be whether this person was a serious threat to the officers or to members of the community. Because here we're going to have to implicate Tennessee v. Gardner. Now, let's look at the video again. Let's try to break down what happened, but we're going to try to look at it at a slower context, frame by frame, so we can all try to understand this from this perspective. So let me pull up my frame by frame showing of this video. Where is it at? Here we go. So we are going to go back. Now the first video, the first angle of the video is no good. But let me pull it back to here. This is when officers are going up to the location. Let me check StreamYard to make sure I'm on camera and you guys can see this. Yes, there we go. All right, let me blow this up. All right. So now we're going to go to when officers are approaching. We're going to slow things down so we can see what happened and see if we can determine what's going on. So this is the first team coming up.
Go, 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 go.
Now this camera is blocked. So we're just looking through this camera, seeing what we can see happen. So now from here, you see one officer, two officers in front of the car, and the car is moving forward. Now the camera's covered, so you really can't see anything. You hear shots, and that's it. And the car is rolling away from the officers. So this video is just really not that helpful for us, right? You can see it, but it's really not that helpful. Let's go to, but the next body camera is going to be a lot more helpful in our breakdown. We're going to start from the beginning. Here we go. Now remember, this is the officer here with the helmet on the I'm going to say on the right hand side here. It's the left hand side of this officer. But anyway, there's an officer you can see with the helmet. That's the body cam we just saw. So now we're going to see the other officer's body cam, the guy who's across from him. Now, I'm stopping it here for a reason. This is the car where our suspect is at. He's sitting in the car, driver's side. Police have now come bumper to bumper with their pickup truck, and now are approaching the vehicle. Now remember, listen for the command. Listen to what they're saying. So let me see your hands. And if we go back, let's go back a couple of frames. You see there's an officer here on the driver's side try to open up the door. If you can look right in between let me go back a little bit more. You see the officer run up to the driver's side door and try to open up the door, and he starts backing up the car. So now there are no officers behind him, but he's backing up the car. Now, obviously, this person's trying to run, right? So, people who are saying that, this is this person is not resisting arrest. That's just ludicrous, right? They've come, they said, "Yo, stop, you're under arrest," but they're saying all the right verbal commands, and police, and he's backing up. So he's trying to get away. Now again, let's also remember that police were warned about this, right? This guy tries to get away. He tries to avoid search warrants. So police were ready for this. They understood that this was what this guy was trying to do. They tried to get him in the car. Let's continue on with the breakdown. Now, they're screaming, "Stop the car, stop the car," right? "Stop the effing car, stop the effing car." And as you can see, the car now is starting to move forward, and you have two officers in front of the car, right? They're now, I'd say this: if this car starts moving forward and these officers start firing into the car that's moving toward a cop, then, I think most people here would say they were justified, right? But again, let's see what happens, because I want to be very clear. The car is moving toward the officers, but when you're talking about use of force, you also have to understand it's not just a lot of officers. Sometimes when I trained in our academy, one of the things a lot of new officers didn't understand is how to lower force when force has to be reduced. Here's an example. Let's say you're at a bank. Let's say you're an officer responding to a bank robbery. The bank robber is firing. You're exchanging gunfire with the bank robber, and that bank robber throws his gun away, puts his hands up, and says, I give up. Officers are maybe 100 feet from him. Officers start approaching the person. They say, turn around. The guy turns around, and the guy starts running. And the cops then start shooting the person in the back. That would be unjustified, right? Because even though the person was shooting at you previously, you've seen the person throw his weapons down, put his hands up, and then start running. Police aren't authorized to just gun that person down, right? They can't do that. That's unjustified because the level of force has been reduced. They can chase that person, but generally you have to reduce force when the suspect reduces force, and that happens all the time. So just because a suspect used force earlier, even threatening force, right? That person was trying to shoot police officers. That doesn't mean when a person then throws away all their guns and starts running from police, that police can just execute them. That's what's called extrajudicial killings. That's Judge Dredd type territory, and we're not allowed to do it in the United States. You're supposed to catch criminals, not kill them. And when you do, if you do have to kill them, it's for a reason that is justified. It's because they are a serious threat to harm someone else. So that's what we have to remember here. I know that was a long colloquy, but I think that's very important to understand that principle, even at this particular case. So let's go on. Let's look what happens here. Again, the car is going forward toward these officers. Now here, if you see on the right-hand side of your screen, there's an officer who almost is hit by the car, right? This officer is almost hit by the car. He's moving out the way. He even has his hand on the car. I'll advance it slowly. So you'll see that officer's almost hit, essentially, and barely gets out the way, right? Now, there's another officer on this side who moved out of the way. So at this point in time, the car is turned. Now, one of the more interesting parts about this case, which I think people have to understand, is that there were, at this point in the video, there were two shots that went into the car. One went into the front windshield. So the officer in front actually did shoot into the front of the windshield. And there was a second shot through the side passenger window. So there were two shots already. So we've had two shots. And now this person the car is pointed in this direction. There's no officers in front of the car anymore. And this person is driving away. So now let's see what happens. Now, again, there's been two shots at the vehicle. If you look, there's no officers in front of the vehicle. This person is fleeing. This is similar to our Tennessee v. Gardner, right? The fleeing felon, right? The person is running away from the cops, right? So now, is this person a serious threat to the officers or to anyone or to the members of the community? There's no one in front of him. There's nothing but green grass in front of him, right? And the car is not pointing at any officers. And this guy's gunning it to try to get away. Let's see what happens. Again, I'm doing frame by frame. So here the person's going. And then now police officers start shooting, and gunshots are going to go through the back windshield. So the back windshield is now going to get shot. And you start to see how the black windshield is going to start getting gunfire. But at this point in time, again, we have to go back to our Tennessee v. Gardner standard. Is this suspect, who is now running, right? This is a fleeing felon. Is this person a serious threat to these officers or to someone in front of him, right? This person is a fleeing felon. So that's the question. That's the standard from Tennessee v. Gardner. Let me play it at full speed. Again, all those shots. Now remember, this suspect was killed, shot in the back. So let's move it back so we can just be clear. pointed at officers. That was the first shot, if you heard it. That was one from the front window and then one from the side. Now, this is where you start getting the rest of the shots, but no officers in front of this person, clear space, officers are behind. This is a fleeing felon, and the rest of the shots come here. And the person's actually shot in the back of the head, right? Back of the back of the neck. Back of the neck, back of the head. That's what we got. So you've seen it yourself. I just want to be very, very clear. You have seen this yourself. Let me pull this back. All right, let me read this super chat. Nate, there is language you may not know on the racism question. There are 3 types: institutional, codified, and law. Fact, I do know about that. Systematic racism, like capitalism and due process, even without race reference, are inherently racist. I agree. An individual CRT confesses language to that purpose. Yes. Okay. So first, institutional racism. I believe, well, I think we have to have a fuller context of what institutional racism is, how it plays out, those type of things. And I think there are other factors. I think racism plays a part, but I think if we're talking about racism codified in law, I think we're past that. I don't think we have racism codified in law anymore. It's a little bit more difficult to answer, but my quick and dirty would be, when you're talking about things like the Black Codes in the Jim Crow era, that's racism codified in law. That was illegal. The 14th Amendment and the Supreme Court have struck that down totally. What now is happening is racism is not codified, but when we talk about institutional racism, we're talking about policies and procedures that may have the effect of having a disproportionate impact on class or on race. So we're talking about, like, for instance, in New York, I always bring up the New York marijuana, where you have this races, people of the same races using a particular drug at the same rate. But when it comes to enforcement, that enforcement is heavy-handed toward people of African American descent. Now, for instance, we're talking about longer sentences, we're talking about even getting arrested, and there are a lot of different factors that are involved with that. For instance, like like in a Black neighborhood, you have to get, like, officers are deemed to have to get 3 arrests every couple of months. Like, you have to have 3 arrests. Where in a white neighborhood, you don't have to have any arrest. So those policies may not be in New York City, which is a very liberal city, they're not going out and say, go arrest more Black people. But when you have these policies in place where in high crime neighborhoods, as a factor, you want to say, well, arrest more people to show that we're doing something in these high crime neighborhoods. Then you have this disparity where you're arresting more people for smoking marijuana in Black neighborhoods, and in white neighborhoods you have it's less of a factor. But this is, I'm actually trying to do a video series on racism in law enforcement, but I want it to be extremely detailed. So that's why I'm holding it. But this is an excellent question. These are excellent points. But we will definitely have a more fulfilling conversation about it. And I thank you for the super chat. $2. Did he turn the car? He could have ran into also. Possibly. But again, we're looking at the facts that are here in front of us. We are looking at the facts. And racism plays a role in all this stuff. But I'm asking you to do something exceptional here in the United States. I'm asking you to take race out of the equation and let's just look at the facts without race. I haven't even mentioned if this person was Black, white, green, or whatever. We're just looking at the facts as they are. And if the facts say the cops were justified or unjustified, so be it. But let's just take race. I haven't even mentioned the race. There's Black officers here, for God's sake. Let's remove that from this conversation, just for this minor point. See where we're at. And then we can come back and we can color it. Your opinion can color it with racism or whatever it wants. But let's just look at the facts dispassionately. And then you come to your decision. And I respect whatever your opinion or decision is, I respect it. But let's evaluate the facts, and then you can spin it whatever way you want. So, back to the facts. So, at this point in time, we've seen the video. We've seen what happened. And we now understand the situation. So let's now apply what we've seen to the law that we have, right? Let's apply this to Tennessee v. Gardner. Let's apply this to Graham v. Connor, and let's see how you come out, right? Because you're going to have to vote. I want you guys to let me know in the comment section how you come out. Is this officer justified or not, based on the law as it is now and the facts as presented, right? And now also with the threat, with the Tennessee v. Gardner standard of immediate threat, you can't say, well, there's a threat that he may hit somebody on a car in the street 2 miles away, or he's driving a reckless and we're trying to stop him from killing somebody because he's driving so recklessly. That's not how it works. It's you're shooting, you're using deadly physical force, which is shooting into a car because you're trying to stop an immediate threat. An immediate threat. That means somebody's standing in front of the car and you're stopping that person from mowing that person down, right? You're stopping an immediate threat. So if there's no immediate threat, if him just driving away and there's no immediate threat, then again, you don't have enough under Tennessee v. Gardner, because that was the argument of Tennessee v. Gardner. That burglar was a threat to somebody else. That's not enough now. The Supreme Court has said that's not enough. So just so we can understand, it's not enough if the person is just running away. Okay. Let me answer this last super chat. I don't believe the cops are justified anymore. But what happens in a car chase if there are inherent risks to life when someone is driving the car? That, of course. But, in car chases, you just don't see. So, all right. I know this was a long-winded one. I'm so sorry. But again, if you guys like this, and listen, I really appreciate the super chats. I really do, because it really helps, because this video really has no hope of being monetized. But that's a question, right? Is there an inherent risk? Yes, there's inherent risk to life when you're driving a car, but police just can't shoot at cars that are driving away. Thank you for the super chat. It was a great question. So I want us to go back to now just evaluating whether this was, the law, and let's see if we can get some resolution to this. So let's get back to it. Do I have anything after this? No. All right. So let's start with Tennessee v. Gardner. Was this person who was driving away? Now, there was a point, and I think we all can realize that. There was a point. Now, first, if we're starting with this Tennessee v. Gardner, this is the first case that we're going to have to start with. Was this person a serious threat to the cops? I think at the beginning of this, yes. When the car was pointed at the cops, if the cops then fired into the car, that's a different scenario, right? We would all agree that driving toward cops, if they're saying stop with guns out and you shoot, different story, right? Easily justified, right? That's the immediate threat to the lives of those officers. But that's not what happened here, right? Let's just be clear. They drove toward the cops and the cops did shoot. So those first couple of shots when he was driving toward the cops, immediately toward the cops, I don't think most people would have a problem with. But again, was that an immediate threat? Driving toward the cops, the cops shooting the car. Now, when he turns the car and there are no cops in front of him, it's only green grass in front of him. At that point, I think this implicates Tennessee v. Gardner, because at that point, he's a fleeing felon. He's in a car driving away. There's no cops in front of him, right? There's no pedestrians in front of him. And then that's when the cops shoot into the back of the car. So is this a violation of our principle in Tennessee v. Gardner? That's something that you have to answer now. Does this violate Tennessee v. Gardner? Was this suspect a serious, immediate threat to someone in front of them? Or was this? Now, if you guys need to look at this, we have to look at the video again. Let's just check it out, just so we're clear. That's the point in which we have to understand. Oops, was this person a threat at that time? Let's just make sure we look at the video one more time so we are clear what we're seeing. Let me pull this back. Remember, we're looking for the part when he's driving away. Now, remember, no cops in front of him, green grass. All the shots from now are going to come from behind the car, and he's driving forward. This is Tennessee v. Gardner violated with this action. That's something you have to now question. That's the question for you, because that's what the jury would have to decide. Is this officer justified? If these officers justified in shooting this fleeing suspect in the back based on the principles under Tennessee v. Gardner. Now, he could have, again, situation has changed, but again, this is a question you guys have to answer. So now we have this person fleeing from the police officers and police officers firing into the back of the car. Tennessee v. Gardner. Nate, show it at full speed. Yes, I will. So we can all see it again. I know it's tough. This is tough. This is not easy stuff.
See your head. Let me see your head. Hey, hey. Motherfucker! Stop the fucking car! Stop the goddamn car!
That's it at full speed. So I know that's it. You know, it's tough. It's tough. I know this is tough. It's Barney. Non-lawyer conclusion. If they had shot a second earlier when the car was moving toward the cops, it would be okay. But the way it turned out, it's not. Again, that is what. Oh, capitalism is racist. Charlie. But yeah, so again, that's Barney's conclusion. But what is yours? What's your conclusion? And base it on the facts and the law. Don't base it on anything Barney just said. Base your conclusion on the facts. You got a brain. You can make this decision. If you're on a jury, you would have to make this decision. So let's go back now, because that's just the first part of our analysis, right? Nate, tell Nate about the car that moved before crashing. Yeah, but again, so it's a car. Somebody's, another car was there. Again, if you want to say that's a serious immediate threat, it is. This is you have to make that determination. It's not me. I can't tell you. What you see here, do you believe the police are justified? Do you believe the police, that was a serious immediate threat to the person in that car at the time when the police shot? Nate the lawyer, at this point, does it not mean that every fleeing felon does not pose a threat? No. That means you have to articulate why you believe that fleeing felon poses a threat. A fleeing felon with a gun shooting at people poses a threat. A fleeing felon just running doesn't pose a threat. A fleeing felon in a car generally doesn't pose a threat. A fleeing felon, somebody in a car gunning it toward police or toward children or toward pedestrians, yes, does. Toward cars, not really, right? Serious threat of death or serious physical injury. That's the standard. It seems like a lot of people are conflicted with this. All right. This one is borderline. John O'Brien. I think the problem is the fleeing felon in the car, which is a deadly weapon. True. High-speed chase. Civilians can get killed. But again, John, you're missing the word here. Immediate. The immediate serious threat. We're not talking about future threat, future harm, right? Yeah, high speed, this. He could do this. Is there a serious threat of death of serious physical injury to someone? That's the standard in Tennessee v. Gardner. Serious, immediate. It can't be something that, I think, it's immediate. If you don't have that, you don't got Tennessee v. Gardner. You violated Tennessee v. Gardner. And now I'm not saying you can't make an argument here. Like there's another gentleman who made the argument there was another car that had to move so they wouldn't be hit, right? Even though that was after the shot. So there are arguments here for both sides. But was this suspect driving away in an imminent, right, serious threat to someone's life or safety? I know it's tough. Nate, the DA cited the case which allows officers to continue to fire at vehicles until the threat is extinguished. Do you remember the name of the case and why is that applicable? It's possible, right? I'll look at that case, because I don't remember any case that allows you to shoot randomly into a car because don't forget, the standard for deadly physical force in the United States, just so we're clear, the standard for use of deadly physical force in the United States is Tennessee v. Gardner and Graham v. Connor. And deadly physical force in particular can only be used to stop someone from using deadly physical force against someone else or others, and even a threat of use of deadly physical force, right? And we're talking about imminent, immediate. That's what we're talking. That's the standard. So I do understand this DA, but when you're looking at this, you need an imminent threat. Remember my thing with the bank robber, right? Throws down the thing and starts running. That's not an imminent threat. Now, again, I believe arguments can be made on either side of this, but that's what you guys have to struggle with. It's not for me to tell you what to think. It's for you to work it out. Work it out. Seems close to violently resisting arrest in the past. Yes, fact. Violently resisting here, fact. And if he flees, they must pursue and effect an arrest, fact. Will he again? He will again. Does that mean you can gun him down from the back? I know this is hard. This is not easy, people. It's never easy. And that's one thing I'm trying, and that's the reason why I do this, because I want you guys to see this is never easy. The people who are telling you this is obviously justified or obviously not justified haven't done any research, haven't looked at the case law, and is just telling you what you want to hear. Think about this. I'm trying to tell you, don't listen. You got to think for yourself. I've given you the law. Read Tennessee v. Don't even believe me. Go read Tennessee v. Gardner. Listen to what the court says and apply it to this case and these facts and break it down the same way. You can do this. Is a YouTube video. Just go to YouTube and look at the body cam footage yourself. You can see this. And if you believe it fits, it's fine. Your opinion is okay. But just make those opinions based on the correct law and the correct facts. That's all I'm saying. And I think you can struggle with this one. This is not easily justified and not justified. This is a struggle. Nate, I think you need to take the camera bias into consideration. See, this is great. I agree. I could see several officers thinking the one in front was going to be hit. Fine. But understand this though. When the last sortie of shots were fired, there was no officer in front, and the car was driving away. The bullets actually went through the back window and hit the guy in the back of the head. So the forensics, the forensics, they determined that it all went through the back window. So, and at that point, there were no cops in front of the car. So, it's possible. You may be right. The camera bias may be something, but unless you have an imminent threat, and again, maybe the officers thought there was an officer in front of the car. I don't know. Does the case law exist? There's a hard line for ongoing situations and change of state. Yes, that's Graham v. Connor. Since they started firing, now actually trying to stop a threat, at what point would one be required to stop? Your response. All right, so me and the officers I'm firing at officers are firing it back at me. I stop firing and throw the gun out. There you go. Officers can't fire, right? I'm trying to run away from officers. I turn the car around and go the other way. Officers can't then fire at me, right? Even if they fired at me to stop me from driving toward them and I turn the car and run, they can't then continue to fire if I turn the car and drive away. Generally, they can't do that unless there's an officer right in front. If I turn around and turn into another officer, then obviously it's a different situation because that's an immediate serious threat. That's the part I think you guys have to remember. It has to be an immediate serious threat. This is a great question, though. These are fantastic. And listen, people, thank you, because these are fantastic questions. Fantastic questions, and I really appreciate it because it's even making me think. Because when I looked at this case, I'm like, he was a felon, he was this. But then when I looked at the video, I'm like, this is not so clear cut. And that's the thing is, these are not so clear cut. And also remember, tie goes to the officer. I know there's a lot of people, BLM, are going to hate me saying that, but that's the way our system runs, right? Tie goes to the officer. That's just the way it is. That's just the way it is. Not serious. He was an imminent threat to himself by recklessly driving. So they shot him. Barney, you're trying to get us killed here. You're trying to get us killed. Let me go to another super chat. A policeman must make an instant decision. Facts, which would require months for a lawyer to make. Of course. If he hurries, he's careless. If he's deliberate, he's lazy. He must be first to an accident and infallible with his diagnosis. No. I believe that's the reason why tie goes to the officer, right? The reason why tie goes to the officer. is the fact of we understand that they have to make these split-second decisions and they're going to be wrong. People are fallible. But I do want to say this, is that I can see this situation going either way. It can. It really can. But you guys have to reconcile the legal fact that if you can make the argument, because that's what I'm forcing you to do, make the argument that if this was an imminent threat to life and safety, then the officers are justified in using deadly physical force, and we have, and the issue's over. But if you can't make that argument, then where are you going with this, right? Then again, this is the struggle. This is the struggle, and I think I'm going to say it. I think there are fair arguments on both sides. I think there are fair arguments on both sides, and I think this is a fair criticism. This is a split-second decision, and I think if you believe that this is justified because of that, I'm not saying you're crazy. I'm saying that that's well reasoned, but I think somebody else can come out the other way, because again, it's about what a reasonable officer would do. How imminent is immediate within eyesight? Again, that's what immediate threat is, right? Is somebody in front of you? And just so we clear too, it's what the officers who are using force, what they can perceive. So if they see children playing in front, then they can obviously do it. Obviously, there's going to be a crossfire issue, so you can't really that's not really a problem. But let's say just even though it's an imperfect analogy, let's say there's a group of people in front of the cars flying there, at a high rate of speed, and the person, and they start shooting at to stop that. That's something would be an immediate threat. That's what you're looking for. It's not a threat that he can be recklessly driving. It's a threat that he can harm somebody immediately, and you have to stop that threat using deadly physical force. That's what the immediate threat is. And the officers who are using force have to be able to perceive that threat, or at least articulate why they perceive that threat. It is clear that the officers didn't know someone was in danger. It's tough from the angle, but I think it goes to the reasonable perception. That's interesting. I think you can make that argument. And Hazley said, I think I'm leaning towards the officers on this. That is, assuming they did not know for a fact that his chose path was clear, they might be under the impression that he was still an active threat. But being still an active threat is an immediate threat to harm someone else. That's what you're looking at, an imminent threat. So being a threat, but being an imminent, we're really talking about being an imminent threat. Was this person driving? Because we can go, I'm going to pull it back again so we can see it. But we the imminent threat. We're not looking at any threat, because a lot of people are making the argument that he could have been a threat to someone else in the future. No, it's an imminent threat. You can only use deadly physical force to stop an imminent, a serious threat that's imminent, right? Somebody's going to do something. Now, obviously, immediacy, it could be, somebody's reaching for something or something like that, or that threat. So that's what we're looking for. But you have to look to see if this person was an imminent threat. And I think there's a question to that. What was he driving towards? A house, a yard? We can't really see very well, but that's because they actually haven't put out the rest of the thing. But let's look at it one more time. So we can see, because it seems like a lot of people, this is the question, right? This is the question. So let's look at it one more time. Go back. And let's just break it down. All right, so now he's backing up. But now he's going to put the car in port. So now let's do this together. Type 1 in the chat at this point in time. He's driving the car forward toward officers. Type 1 in the chat if you think if the officers fired at this point, they were justified. You have a car, a 2,000-pound vehicle driving toward officers with guns drawn, telling him to stop the vehicle. If you believe they're justified, if they would have shot at this point in time, because a couple of officers did shoot. If they shot at this time, do you think those officers were justified? 1 is yes, 2 is no. Right? So we'll be breaking it down. I see nothing but 1s in the chat. Is there any 2s? Right? This guy is driving toward officers with guns drawn. It's an obvious, right? Okay, thank you, people. Thank you for your candor. We're going to move this thing forward a little bit. So let's check it out. Here we go. Now, even at this point in time, you see the officer up here got his hand on the car, right? He's still driving toward the officer. If the officers shoot him now at this point in time. Are the officers justified? 1, for justified. 2, for not justified. It's very, I think, you literally have an officer with their hand on the car in front of the vehicle, right? Here we go again. Are the officers justified if they shot this guy dead in the car now? That's where we are. 1 for yes, they're justified. 2 for no, they're not justified. And so you got Jimmy Dean saying they're not justified. Interesting. But Crank Yanker said too. but so you guys see, right? There at different points, there are different things going on, right? Different points, the cops are justified, right? So we're not. So again, this is not an all or nothing here. There are different points where the cops would be justified in using force, but now the video continues. They haven't. I think. So I don't know. Did I put the video the sound on? Is the sound on it? Yes, because you should have been able to hear that shot. So now I'm gonna go back because you'll hear the first shot. Did you hear that? That was the first shot. It happened right here. So was that shot justified? Right? Was that first shot justified? Again, so we're going back to it, right? We're going back to it. That first shot, driving toward an officer, you heard the first pop. Was that first shot justified? That's what we're talking about now. 1 or 2. That first shot we just heard, we all heard that first shot. He was driving toward an officer. We heard the first shot. That was the first shot that went through the windshield, right? 1, right? 1. Now, this is where things get complicated because he's still alive. He's been shot at once. And there's another shot that went through the window. So we got 2 shots. Everybody in the chat, except for I think a few people, think it's not justified, right? Person still alive. 2 shots. Let's continue on. Let's do this. Let me do it frame by frame. So we got 2 shots, 1 through the glass, 1 through the windshield. Now, at this point, daylight. Only thing you see in front of this car is grass. Now, I'm going to rewind it back a couple of frames so you can see the grass in front. This is from earlier, but you see the grass in front. There's nothing between the officer and the sidewalk. There's some cars there, but it's nothing but daylight, right? This person can just drive up the sidewalk. So that's what you're seeing. You're seeing nothing but daylight. So let me go back to the part where he's driving away. So here we go. So now there's no officers. The officer on the left, you can see a little officer right here on the left-hand side, but he's not even in for the vehicle. So here we go. So here is the person driving away. Now remember, no shots have been fired yet, right? Except for the 2. We have 2 shots that were fired when he was driving at officers. No other shots have been fired at this point in time. Just so everybody's clear, no other shots at this time have been fired. Except for the initial 2 through the windshield when he was driving at the guy. Now, at this point in time, no officers in front of him. You see all that green, right? We just looked at it, all that green. And he's driving away from the officers. All the officers are behind him. Is these shots, now they're about to load up into the car, all through the back window, right? Shoot through the back window and hit him in the back. Tennessee v. Gardner says you cannot shoot a fleeing felon in the back unless they're a serious threat, an imminent threat of danger to police officers or somebody in the community. They're about to shoot into the back of this car. 1 for justified, 2 for not justified, because all the rest of the shots are coming from the back. I leave it to you. I leave it to you. This is what we're talking about. Of somebody who's alive, somebody who's been shot in the arm, somebody who's driving for daylight, no officers in front of them, no people in the thing. And is this person is this person a serious threat? Jesus said this is dead. That's why people come watch these videos. That's welcome to the hell. I said I put my audience through every week when we do these things. This is hell. I know this is hell. Look how many 1s and 2s. It's crazy. People are saying it's an easy two. It's an easy one. It's tough. This is tough stuff. I feel bad where, I don't mean to even laugh at this. This is serious. But this is not easy, people. This is not easy. This is not easy. My God. But the one thing that you now know, the one thing that when you believe this video, you've learned a lot. I just taught you two fundamental cases in police use of force. If you've never seen any of my videos, you've just seen two fundamental cases in law enforcement broke down, Tennessee v. Gardner and Graham v. Connor, and you're seeing it applied in the real world, right? There are, and this incident is a plethora of gray, right? There are pieces of this incident where I think everyone agreed in the chat, except for like one person, that were justified. But now we're at the point where it's 50-50, right? There's a lot of people who believe this is not justified, but there are a lot of people who believe that it may be justified. Matter of fact, I'm looking at it. It seems like more people believe that's not justified at this particular point in time. So it's, so really, really, really understand this. Nate the lawyer, if you live in a house in front of the car, it's easy. Not really, no. Because again, it's a serious imminent threat to life and safety. A house, we don't shoot people for driving the houses. That's just not the way it works. I understand your point, but yeah, it's got to be an imminent threat, not there's a house in front so we can. No, that's not the way it works. I'm sorry. Once he tries to run over the officer, boom, he becomes a fleeing forcible felon. Okay, yes, I mean, once he becomes a fleeing forcible felon, police will no. See, this is where you go wrong. This is where you go wrong. No, if he's not an imminent dangerous threat to the officers or anyone, they cannot use deadly physical force. This is the problem. You're right. Part of your analysis is right, but de-escalation of force, that is manslaughter, what you're talking about. There's a difference between a status crime. When someone is a fleeing forcible felon, as you call it, that's a status, right? But that status changes, right? When you're not, if that fleeing forcible felon throws up his hands and starts running away with his hands up, you can't shoot him because you've determined he's a fleeing forcible felon. That's the difference here. It's a good question, but you're just technically wrong on what police can do. They are not allowed to do that. I would argue that turning through the officers and attempting to flee was all one action. Agreed. One reasonable officer could expect to change his force level inside of that tiny window. No, of course. Yes, you can, right? If he's not driving at anybody, you don't shoot. And again, let's see, for this super chat, if they were shooting, all right, let's say if you have an officer right in front of him, let me put this screen up. Let me do it this way. So let's say here's the car. And let's say here's the car, here's the officer. If they start shooting and he's turning away from the officer and they're shooting, that's a different story than if the officers are behind him and he's driving away, right? Those are two different scenarios. So now let's look at this, because it depends on when the officers shoot, because that's what it seems like you're alluding to. So when are the officers shooting? Are they shooting when it's clear there's no officers in front of him, or are they shooting during that saute? So I'm going to move it back so we can just be clear. So here was the first shot. Oops, let me go back. So when he turns now, there's no officers in front of him. He's got a clear lane. And let's see listen for the officer's shots. Yeah, he's not. So again, at this point in time, he is shooting. They are shooting him when there's no officers in front, nothing but green grass, and he's going away. That's what happened here. But great question, though. A suspect shoots at officers, then turns and flees and still holding weapon. What happens? Again, it depends on if that person is a serious threat to the officers or people in the community. You can make an argument that, yes, the person holding a gun who's been shooting at officers, maybe shooting even behind at officers, can be shot in the back. But again, this is very fact dependent. I'm trying to deprogram you from this whole thinking of it's so easy, because it's not, right? Someone holding a weapon that's running from officers who've been shooting at officers, that's a different scenario. And I think you're right. That would be different, but that's not what we got here. That's not what we have here. We have someone driving away in a car. In my opinion, bad tactics lead to the death of Anthony. There is no reason to place yourself in front of a vehicle. Fact. Forcing yourself to shoot when he flees. This is very true. This is very true. Makes me think you're a law enforcement officer, because that's what we used to say. No, don't stand in front of vehicles unless you want to shoot somebody and be judged by 6, right? I mean, judged by 12. I'd say at this point it had to be a 2. Split-second decision after the facts are easy, but at that moment, every officer needs to stand down and pursue. Yeah, Jesus, you see, you came in a hard 1 before. Now you're talking about 2. Uh-oh, you've changed your story. Thanks for the super chat. I might have to change my stance. I do believe it's not justified on the basis that the officers knew it was safe enough to shoot while not harming bystanders. That's fact, because don't forget you got the crossfire part. So you're shooting and you know there's nobody in front of. For those who don't know, for weapons training, and this is just be a quick and dirty version, but for weapons training, you have to be able to identify your target, know what you're shooting at, and you got to know what's in front of your target and behind your target, right? So let's say if somebody's shooting at me, but they have a whole bunch of school kids behind them, I can't return fire, right? Because I can hit one of those school kids. So you can't just fire your weapon just because somebody. You have to know those kind of 3 principles. Being able to identify the target, knowing what's behind the target and what's in front of the target, because you don't want to harm anybody else. So this is definitely correct. And for the fact that the officers knew that they can shoot because they identified the target and nothing behind and in front, does lend you to believe that they know that there was no officers in front, because they shot, they would have been shooting at the officers. So, oof. Well, this concludes our breakdown. So let me just go through this one more time. So before we leave, we can just understand where we're at, and I can leave you guys be, because, and if you guys enjoyed this breakdown, let me know in the comments section. If you guys enjoy these live breakdowns, because I like to do them produced, but I like to have this conversation because I think this conversation is valuable, because a lot of people have questions and we can really break this down. So, backstop. So we can break this down and I can really get to your questions, but I used to always tell my students this at law school. It's a way of thinking. It's not a way of just knowing the answer is bullshit. Thinking about how you get there. That's, if anything, if no one ever watches another one of my videos, if the people in this chat today who've watched it today understand that it's not about the outcome, but how we get to the outcome and whether it's legally permissible. That's the value of this. I would have done more. I've done more than I could have ever done at a law school. And that's what I want you to understand. Nate, you should have talked about NCG 1525 subsection D. Yes, but I'm not applying state law because I don't want to get into the legal advice and state law and all that stuff. So what I'm just doing, applying the federal standard that most state laws have to apply to. But I do agree with that point, but I've specifically stayed away from all these cases in state law because none of these cases can violate Graham v. Connor, nor can they violate Tennessee v. Gardner because they're the constitutional standards. So he is right. That is the North Carolina general statute about the use of force. They codified Graham v. Connor and and Tennessee v. Gardner into state statute. But I just hate getting into state statutes, especially when I know the federal standard applies to them all. But thank you, and that is and you're right. I definitely appreciate that super chat. I feel like this case should make SCOTUS to refine Tennessee v. Gardner. They did. They refined it with Graham v. Connor. So let me wrap this up so you guys are clear where we're at. Let's go to the tab. Let's go back to the presentation so we can wrap this up. So we had the 2 cases, Tennessee v. Gardner, Graham v. Connor, both from the 80s. Serious threat for Tennessee v. Gardner and objectively reasonable. So for Tennessee v. Gardner, remember we have the fleeing felon, shooting them in the back is a no-no unless they're a serious threat of danger to themselves or other people. Was this the case here? Was this the case here? A lot of people are saying yes. Some people are saying no. I'm going to leave it to you in the comment section to let me know how you think. It's going to be a very, very powerful conversation because I think there's a lot of unanswered questions here. So we have the serious threat element. Was this person driving away at the time that the person was driving away? Was they a serious threat to the police or to members of the community? Some say yes, some say no. We also got to look at Graham v. Connor to see if the officers were objectively reasonable. That's our standard. 911 call, dangerous felon, 2 warrants, drug warrant, someone who has a predicate history of violence against police. That's what they were going into. How does that factor play to whether a reasonable officer would be prepared to use force? Resisting arrest. He's obviously was resisting arrest. I don't think, there's no opinion with this. He was resisting arrest, right? This is not an opinion-based part of it. He was obviously resisting arrest, right? He was obviously resisting arrest. Yes, NG5 is relevant. Yes, it's absolutely relevant, but that statute cannot violate the constitutional principles. If it does, that statute's unconstitutional. So that's why it's not relevant. No, it's relevant to the case, yeah, because that's North Carolina, but it's not relevant to this analysis because if it violates Tennessee v. Gardner or it violates Graham v. Connor, it's unconstitutional. So let's go to the last one, which is the serious threat. Was he a serious threat? We saw that in some instances, he was a serious threat to the officers. He was driving toward the officers. The officers did shoot when he was driving toward them. But there's also this last piece of it is the de-escalation of force. When the person wasn't a threat directly to the officers, was that also appropriate for them to continue the force? Let me answer a couple of last questions before we get out of here. Let's put this down. Okay, so here we go. This is the Q&A time. Just make sure you tag me so I can know. Nate the lawyer, you haven't voted my question. Okay. Can you show us in 43 seconds the officers were able to stop and tape and analyze the situation? No, they could not. Only thing you can do is the person a threat to you? If the person a threat, when the person is running away, you can't shoot in the back, right? It's not, it's what a reasonable officer would do. That's why they go. I think it's 44 seconds, 43 seconds, whatever. But that's what you do. You're saying an officer at the scene, if someone turns and runs, that takes 5 seconds. Can the officer still shoot? You don't say, well, it's only 5 seconds. So when the guy turned, the officer can gun him down in the back. You evaluate this. So, I'm not avoiding the question. It's just that time frame. If I'm having a gunfight with somebody in 10 seconds and then they drop the gun and turn around and run away, I can't then gun them down and say, well, it was only the whole thing took 30 seconds. There's analysis to this thing, and you make the analysis based on what you see. So it's an interesting question, but I agree. The time is short, and generally, that's why ties go to the officer. A tie goes to this officer. Would local law be relevant to the question of reasonable officer? Yes and no, because don't forget in Tennessee v. Gardner, the law was you can shoot fleeing felons in the back. That was the law. That was the state law. State law said you can shoot fleeing felons in the back, and that law was struck down as unconstitutional in Tennessee v. Gardner. So that's why. So the state statutes are great, right? Because the state statutes can be more restrictive than the federal statutes, but you can't do it. Nate the lawyer, how would you defend these officers? I would defend them. I would say, all right. How would I defend them? If I was defending these officers, I would say they were justified. I would just say it was all continuous. I would say that when the officers arrived to the scene, the person started driving toward the officers, this was all continuous, right? They were shooting to stop the threat. And perception and all this other stuff. I would make the argument that Tennessee v. Gardner, they didn't violate Tennessee v. Gardner, and their thing was reasonable. I would use most of the arguments that people were using in the chat. But then if I was prosecuting these officers, I kind of do the same exact thing. Break it down. At this point, there was no here's the standard. There was no immediate threat here, so it's 50-50 thing here. Nate the lawyer. Could these officers have disabled the car by shooting at the tires or something? I got to see what their policy is, but generally your policy is, you shoot to stop a threat. You shoot out tires. It all depends on what their training is. Sometimes it's tough. These marksman type shots, shooting people in the legs and shooting tires is a little different. I've never been trained to shoot tires, but maybe this is a SWAT team or something like that. So maybe they may have different training that allows them to do that. But generally that's just not what they're trained to do. But again, that's a good question. Nate the lawyer, a bit off topic. Do you feel about the educational period what do you feel about the educational period of Leos compared to here and then the Nordics, where it's years? Think it would help in cases like this. Facts, but I think we do about 6 months with the training here, which I think is good. So I think 6 months is is reasonable, but don't forget you have more training every year, because every year we're retrained. You got to requalify for your gun, you got to requalify for your ASP and all that stuff. So every year, so it's not really just a 6-month training and that's it. It's an ongoing training, of course. So like in the Chauvin trial, those officers were trained 40 or 50 times in use of force and all this other stuff, and they go through every year they go through a 2-week training. So I think the training here is reasonable, but more training, yeah, it's always good to get more training. But I really think that that the training here is sufficient. But maybe we can always rethink things. So let me see. No, we need to rethink lawyers. That's probably true. That's probably true. I'm not telling you to think like a lawyer. I'm just saying you should think about this just as a factual approach. And again, it's okay if you come out. Whichever. That's one great thing about my channel. No matter how you come out, I don't care, because opinions are what they are. But the facts, we should all agree on the facts and then figure it out on each other. Shooting tires is not easy. Hollywood myth. Yes. Anybody who shoots knows you can't. Shooting people in the arm and the leg and shooting out tires. It's tough. It's tough. It's tough. A violent felon had a deadly weapon. Well, I disagree with that. Deadly weapon would be a gun, something like that. This is a dangerous weapon. So the dangerous weapon, yeah, but every felon with a car would have a deadly weapon. So that doesn't mean you can kill them all, right? It all depends on what you're doing with that car. Going toward the officers, yes. Driving away from the officers, no. So, good point, but I disagree with the characterization of a car as a dangerous weapon. I mean, any felon in a car, could be killed. I just disagree with that. And Secrets Girl says, don't forget to use your gavel on the like button. Yes, like, share, subscribe, do all that great YouTube stuff. Thank you again for all the super chat. And thank you guys again. This was an amazing stream. I hope you just learned something, and I hope you guys enjoy going through this. Next case, also, if you guys want to, look, in the comment section, what other cases you'd like me to break down this way, please let me know, because we'll definitely go through it. And at this time, I'm going to get out of here. Thanks again to all my mods for keeping the chat safe. Thanks again for all the fantastic questions. You guys pushed me a lot with this. You guys were not letting me get out of this. This was justified. But the fact that you thought about it, the fact that we weren't screaming at each other, and the fact that we were looking at a fact-based approach is what it's about. And I think we should all leave understanding that this was an excellent stream, because we were arguing about the facts. We weren't arguing about anybody's. And again, we haven't even talked about any race or race-based racism, anything about that, right? We were talking about the facts, and we can have a great conversation just about the facts of actually what happened. Shocking, right? Shocking. Nate, systematic racism is a non-factor in our country. All right. Compared to rural Appalachian, to historical Black neighborhoods, institutional such as capitalism do however respond to cultural bases some deserved. Interesting. Is a non-factor. I don't know. I have to think about that, because I still think we do have systematic racism, but just in pockets. Like, I don't think it's as a huge problem as some people make it out to be, but I still think there's a problem there. And I think the problem may be one of negligence. It may not be one of people wanting for it to be racism. But we'll see. We'll see. Again, when I finish my little series and put it up, I want you, I want you guys to tear it apart. I would love you guys to tear it apart, because I do, I think racism plays a part in our opinions on these things. Like this, I don't think this had anything to do with racism, right? I just don't. I know a lot of people are going to be like, "Oh, Nate is obvious." No, but I don't think this police shooting had anything to do with racism. I think what it had to do is that if you look at the situation, look at the vigorous discussion that we've had. At one time, we haven't even discussed it. Matter of fact, I have not even shown you a picture of the guy. You don't even know if the guy's Black or not, right? We could be talking about a white guy if you don't know this case. We could be talking about a white guy. Right? We could be talking about a white guy who was shot in the car, right? So that's what I'm talking about. And if we can have a conversation like that, understanding how the law works out, then I've done my job. Now, go listen to the race baiters, argue about how the race or, how the race is involved and how this is because he was a Black guy. But I haven't mentioned race at one time. And I think you can still come to find out that this was unjustified without even implicating race. But I also think you can find that this may be justified, without implicating race. So again, it's up to you. So, hey, My name is Nate the Lawyer. Thank you guys for watching. And as always, the conversation continues in the comment section. Jury question for the day. Was this justified based on the standards from Tennessee v. Gardner and Graham v. Connor, or was it not? Your question. Can't wait to see what you say in the comment section. My name is Nate the Lawyer, and I am out. Peace.